Hello all. So today we will be talking on impact of COVID-19 on residential status of individuals under income tax. As we all know, residential status refers to a person's status with reference to the question of how long he has stayed in India for the past few years. As we know that the world has witnessed a gigantic impact on the coronavirus pandemic, that is COVID 19, leading to a straining the local medical infrastructure, restriction on travel, and the social contact, and unprecedented destruction to the global economy. The pandemic has forced several businesses to curtail their operations and shift the work parameters from a business premises to homes of the employees. The aftermath of a suspension of international travel left people stranded in a jurisdiction which otherwise might have been a mere temporary visit. This temporary dislocation could have an impact on a residential status and the taxation of such people as well as the enterprises of their work. India is no exception, and the residential status of an individual stranded in India for an unforeseen duration, which are otherwise employed outside India and are residents of such other country, may alter foisting them with the status of a resident in India due to prolonged visit during the pandemic period. So, first, I will be talking on the determination of a residential status in India for individuals. An individual may be classified into any of the three broad categories on the basis of a residential status. First, resident and ordinarily resident, which we call it as a ROR. Second, the resident but not the ordinarily resident, that which we call it as a resident but not ordinarily resident. Third, non-resident, that is we call it as a non-resident, NR. The residential status of an individual is dependent on the period of stay in India during the particular financial year, starting from 1st April to 31st March, referred to as a previous year, and is to be determined individually for each previous year. The status may vary from year to year. Section 6 of the Act provides the following conditions on the fulfillment of any one of which an individual qualifies to be a resident in India in any previous year. First, he has been in India during the relevant previous year for a total period of 182 days or more. Or, second, he has been in India for a period of 60 days or more in the relevant previous year and during the 4 years immediately preceding the previous year, he has been in India for a period of total 365 days or more. Third, he has been in India for 60 days or more in India relevant previous year and during the 4 years immediately preceding the previous year, he has been in India for total period of 365 days or more. The individual who is not fulfilling either of the aforesaid two conditions shall be treated as NR in India. The Finance Act 2020 has introduced certain amendments under Section 6. Through this act, a new provision was added, that was Section 6(1)(a). According to this section under the income tax, an individual being a citizen of India having a total income other than the income from a foreign sources exceeding 15 lakh rupees during the previous year shall be deemed to be resident in India in that previous year, if he is not liable to pay tax in any other country or territory by reason of any other criteria of similar nature. Moving further, now I will be discussing classification of resident into ROR or RNOR. Once an individual qualifies as a resident in India, he is critical to determine whether he is ROR or RNOR. If such individual fulfills any one of the following additional conditions, he shall qualify as RNOR. He has been a NR in India in 9 out of 10 previous year preceding the relevant previous year, or he has been in India for a period of 729 days or less in 7 previous preceding the relevant previous year, or in case he is an Indian citizen or PIO having income from Indian sources exceeding the amount 1.5 million during the previous year and staying in India for a period of 120 days but less than 182 days during the previous year, or he qualifies as a deemed to be resident under section 6(1)(a) of the Act. If the individual does not fulfill all the aforesaid conditions, he shall be treated as ROR. So, at last, the spread of COVID-19 stranded man and hours in India due to complete suspension of international travel. As a result, many individuals face the risk of becoming a resident in India due to their forced extended stay. To mitigate this risk, Central Board of Direct Taxes issued in the month of May, that is the year 2020, extended the relief to the NRs individuals who came to India as a visit before 22nd March 2020 by excluding the period from 22nd March 2020 to 31st March 2020 from the number of days stayed in India for the purpose of determination of residential status for previous year 2019-2020. It was expected by the CBDT that the tax department may issue similar guidelines to address the challenges faced by the taxpayer to determine the residential status for the year previous year 2020-2021 also. While no such guidelines has been provided after Supreme Court's intervention as a result of the petition which was being filed for the determining of his residential status in India. CBDT, Central Board of Direct Taxes, issued in the month of March 2021, providing insights of the existing provisions of the Act and the DTAA in relation to determination of a residential status. The pandemic has resulted in a severe hardship to the individuals as well as the enterprises and has reshaped the conduct of business. While the Central Board of Direct Taxes circular and press release provided very limited guidelines to the decide upon the residential status of the individuals and the foreign companies. They rather enlightened with the existing provision of the Act. It is pertinent to note that the circular does not provide any explicit guidance for the determination of a residential status for an individual or other taxpayers, and merely highlights the liberalized provisions which are available with respect to determination of a residential status under this Act. So, with this, I conclude that COVID has played a big role in this particular pandemic related to the residential status of an individual. Thank you.